Well, welcome everyone to CED Office Hour Live, where we talk about all things community and economic development. My name is Ambrose Moses, and I'm one of the extension educators in the Community and Economic Development Program Unit at Central State University in the Cooperative Extension Service. Our topic today is the power of LLCs, insights from the Apple Computer Partnership. And I'm going to go ahead and uh, share my screen.
We
Right.
can see the slides clearly.
All right. Okay. Thank you. Thank you for that, Amber. Okay. So, as I indicated, my name is Ambrose Moses. I'm with Central State University as an extension educator. And our topic, the power of LLCs, insights from the Apple Computer Partnership. Now, this is part of the uh, program that we have, one of our newer programs, the Legal Environment of Business and Community. Now, the legal environment of business and community is designed to educate individuals, businesses, organizations, and communities about the law and how it affects daily life. The program aims to provide a solid base understanding of law and the legal system through which it is deployed, utilized, and imposed upon businesses and community life. The knowledge gained will encourage, empower, and enable the individuals, businesses, and organizations and the communities to make better informed decisions. The better informed decisions will result in positive changes that improve the quality of life in the communities that we serve. We will discuss more detail about the legal environment of business and community during our CED Office Hour Live episode on February 23rd. So in a couple weeks from now, we'll go into more detail about that. But today, we're going to talk about one of the first matters that all business owners and organizations must face that is heavily impacted by law. We will use the origin story of Apple Computer Company to give us some context in which to engage on this topic. Now, I did want to go ahead and put up a quick little disclaimer here that even though we will be talking about law-related topics, this presentation is not legal advice and is not intended to be legal advice. If you have a need or would like to talk to counsel, you should contact an attorney that is close to you in your jurisdiction. All right, so Apple Computer. So Apple Computer started back in 1976. Today, the company, as a partnership, today the company is known as Apple Inc., as a corporation. So it's changed the structure. And it is one of the largest corporations that we have in the world. Looking at the slide here, you can see that Apple has a market capitalization of $2.4 trillion. And the market capitalization is calculated by taking the number of shares that the corporation has that's being traded, the number of shares, and multiplying that by the price or cost of the per share. And Apple comes out at $2.4 trillion. And you'll see over to the right, the top 5 companies by market capitalization, and Apple is listed as number 1 with that $2.4 trillion, and second is Microsoft at $1.98 trillion. So these are some very large companies, and they are technology based. But it had sort of humble beginnings as a partnership back in 1976. So a lot of folks know that in terms of the founders of Apple, we think of Steve Jobs, we think of Steve Wozniak, but there was actually a third founder of Apple whose name was Ronald Wayne. He was a little older than Steve Jobs and Steve Wozniak, the two Steves. but all three of them worked together at Atari, which was a video game company. So they all worked together there, and the two Steves started having an idea to build and sell computers, and they had known that um, Ron Wayne, that he had had a few businesses and that he was a little older than them, and he seemed to be knowledgeable on quite a few things. So they started to talk with him, and they got together and met with him at his house and asked if he would become involved in their business that they were thinking of doing as a partnership. And they were impressed at that time, that Ron Wayne agreed to do it. And as they sat there, he pulled out his typewriter and began typing up partnership agreement, for them to sign. He's not a lawyer. He wasn't a lawyer, but he was, sort of a smart guy, and he started typing up the partnership agreement between the three of them, where Wozniak was going to have 45%, Steve Jobs was going to have 45%, and then Ron Wayne would get 10%. And they were looking at Ron as the sort of the tiebreaker, the sort of the older voice in the room, to sort of calm things down if there's any kind of disputes. Well, as you can see here from this slide, Sotheby's is an auction house. Back in the early or in the 1990s, early 1990s, Apple was going through a couple of different issues as a company, and Ron Wayne had copies of his partnership agreement, and he ended up selling it for somewhere between either $500 or a couple $1,000 to some folks who wanted to collect that kind of memorabilia. But it ended up back in 2011 at Sotheby's being auctioned off, and they were projecting that this agreement, this contract, was going to auction off somewhere between 100,000 and 150,000. They were surprised when ultimately it sold for almost 1.6. It was $1.59 million. So instead of 100,000, they went for 1.5 million, a little over 1.5 million. And that's just the contract, for the partnership, as well as the dissolution or withdrawal of partnership that was filed, which we're going to talk a little bit about here. And so this was a display case that you see where whoever purchased that collection of documents had it on display. And I guess if you're going to spend $1 million, you're going to display whatever it is that you just bought. So what we have here in this slide are the collection, another view of the collection of documents that were purchased at that auction. And there's the partnership agreement. Let me see, where is my one second. I don't use my laser pointer that often. So in the documents that we have here, you have the partnership agreement up here. These are 3 pages up towards the top. Then you're going to have the amendment to the partnership agreement down here, the bottom document. And then the yellow document is what was filed with the county office in Santa Clara County, California, when they did the amendment to the partnership agreement. And essentially, what ended up happening was that after the partnership agreement was signed, Steve Jobs went out and he said he was going to find someone to sell them some build them some computers to start selling. He went out and started getting some orders, and he ended up starting out getting a loan so that he can purchase these computers that he was having built. And so they entered into the partnership, and we'll see some of the documents here from the Apple's records on April 1st. And Steve Jobs went out, got the 15,000 as a loan. Then Ron Wayne, who had by this point started recovering from some of his business losses and challenges over the years, started thinking that there's some risk involved in this. He didn't want to lose his house or his car. At that point in time, the two Steves, Steve Jobs and Wozniak, didn't have anything in terms of any real assets. And so Ron Wayne was looking at it as, well, he has a lot to lose. He has some things that are at risk. And so he, after a few days, after a couple of weeks, decided he wanted to end the partnership. He wanted to withdraw from the partnership, which is the amendment that we see here. So his 10%, he ended up selling back to the partnership, and he was paid in the area of $800 for that 10% interest in Apple Computer, because he was, sort of concerned about being exposed to the debt and the risk of that business. And so he gave it up, and today he doesn't have any ownership interest in that $2.4 trillion company that he was part of founding. So, and then this is again the document that was filed with the county of Santa Clara concerning the withdrawal of Ron Wayne as a partner. So when we look at this, when we talk about business formation, and like I said, we're going to talk a little bit, focus primarily on LLCs today, but the issue of liability is an important aspect to consider. So Ron Wayne was on the right point in terms of thinking about and being concerned about, how is this going to impact liability-wise, impact him liability-wise. So let's say in this example here, if the Apple Computer Company has a partnership, it had assets of $5,000. So let's say they had some of the equipment that they had bought and some other things that they had pulled together, and it was valued at $5,000. And then they went out, Steve Jobs went out, got the $15,000 loan. And let's say they defaulted. They didn't pay any of that loan back, and they defaulted on the terms, and so they now owe this $15,000 and only have $5,000 in assets. Well, that the person who had loaned them the money would then be able to pursue a claim against Apple and recover against whatever assets they have. So they could take the $5,000 in assets that the partnership had, but there's $10,000 still left unpaid. So a question would be, would the owners, in this case, Jobs, Wozniak, and Wayne, would they be personally liable for that $10,000? And depending upon the structure of the company, they would. So again, Wayne was on point in terms of being concerned about that. If it was a sole proprietorship, yes, they would be liable. A partnership, which is what they formed, they would be liable for that $10,000. And the two Steves didn't have anything. Wayne had a house, a car, had his family to think about. So he felt he was really, really at risk. If it was a corporation or an LLC, then they would not be personally liable for that. However, in 1976, LLC was not an option for Wayne, for the guys to actually do. It didn't exist as an option in California at that time. So the only other option would have been corporation. But if they had formed it as a corporation, that would have addressed his needs. So even though he was a smart guy, was able to sit down and sit at the typewriter and type up a partnership agreement, he made a major error in not going and sitting down with legal counsel to help them to structure that business, because really typically just a new lawyer right out of law school would have told them, just set it up as a corporation to limit your personal exposure. So that was one of the things that they should have done right there in the beginning. But as we look at it in terms of the legal nature of operating the business, again, one of the first decisions an entrepreneur faces is what legal structure to establish for his or her business. And we just saw how in that area of liability, how it differs based upon what structure. And we'll just go through quickly here just to compare those briefly, and then we'll get into some more detail about the LLCs. So the sole proprietorship is the most simple form of business structure, and it's a single individual engaged in a business activity. And as we saw from the example, the owner is liable for all debts of that business, as a sole proprietor. Tax-wise, for the tax consequences, they will report the tax consequences on their personal tax return using a Schedule C to do that. And there are no formal documents needed to create the sole proprietorship. It's the most basic, simplest form of business operation. Next, we have the partnership, which is where we have two or more persons that come together to engage in a business activity. In the example with Apple, we have the partners. They started with the three partners. They had a written partnership agreement. That's going to vary. It may vary by state law whether it has to be in writing or not, but it is helpful to have a written partnership agreement because it will indicate who the partners are, such as the three partners in our example, what percentage of the company they own, if we're going to bring in new partners, or what happens if a partner wants to leave the partnership. All those kinds of things can come into play. In terms of liability, the partners are ultimately liable for the debts and claims of that partnership, which was the issue that we had here with Apple. The original partners, especially Ron Wayne, was concerned about that personal exposure, which prompted him after a couple of weeks to withdraw from that partnership. Then in terms of the tax consequences, the partnership is a pass-through entity, meaning that the profits and losses would ultimately be reported on the partner's individual tax returns. Right. The next structure we have is the corporation, which is the most formal of the business structures, and it was available to Apple computers when they set their business up as a partnership, but they either didn't know about it or didn't understand it. And history is what it is at this point. But it's the most formal of the structures, and recognized in all of the states. All states have laws regarding corporations, and it's formal because there's a requirement to have shareholders, board of directors, and officers. And these are three distinct roles within the corporate structure. The owners, shareholders are the owners. They elect the board of directors. The board of directors govern the corporation, and they oversee the general direction of that entity. And they also hire the officers. President, vice president, secretary, treasurer are officers of the corporation, and they run the day-to-day affairs. So you have shareholders who elect the directors, and the directors hire the officers. In Ohio, it's possible to have a corporation, under Ohio law, a corporation that has one individual who is the sole shareholder, sole director, and sole officer of that corporation. Now, when we look at the areas that we're comparing here, ownership-wise, the corporation is going to be owned by the shareholders. You're going to have partners in the partnership. You're going to have the sole proprietor in the sole proprietorship, and then you're going to have your shareholders in the corporation. And it's one or more persons that's required to own the corporation. And this is persons in the legal sense, meaning individuals, but it could also include other corporations or even limited liability companies as the shareholders of a corporation. Now, you will notice at the bottom of this slide, we have quite a few more documents here. Articles of incorporation. So that's one of the requirements to form a corporation. When the articles of incorporation are filed with the Secretary of State, then that corporation comes into existence and it's recognized as a person, separate from its owners. So essentially, you're creating a person, a legal person with a corporation. As a result of that, that person, that corporation, is liable for its own debts and claims. So the owners, the shareholders, are not personally liable for the debts and claims of that corporation. So in our example, if instead of the partnership that Apple had done, if they had set it up as a corporation, then Ron Wayne would not have any personal exposure to that loan that the corporation had gone out to get. So if there was a default and the assets got wiped out, there was 10,000. His personal residence, his car, all of that would be protected from liability in that circumstance. So he would still have his 10% interest in Apple, and he would be a billionaire today if he had made a different choice back then in 76. In terms of tax consequences, the corporation as a person itself is responsible for its own tax treatment. So it's going to file a tax return and it will pay taxes on its profits, or it will report its losses and carry those forward as corporations will do. Then, in addition to the articles of incorporation, which are in Ohio, which are on the public record, the corporation is also required to have corporate bylaws and then minutes and resolutions of minutes of the shareholders and the directors. And those items, the bylaws, the minutes and resolutions, are maintained internally within that corporation, so they're within the corporate record. So they're not on the public record. They're not, people can't go on the internet and find those. Those are internal to the company. Then we have our entity that we're going to really delve into a bit, the limited liability company, or LLC, which is the most popular of the business structures that we have today. Ohio just recently had, in terms of the number of businesses that were formed or filed with Secretary of State, we had the second highest amount this past year in 2022. There was an all-time record in 2021 in terms of businesses that were filed, and then last year it was it's still pretty high, but it was the second highest number. And so with the LLC, it's more of what we call a sort of a hybrid structure. So there are some aspects that are similar to a corporation, and then there are some aspects that are similar to the pass-through of a sole proprietorship or a partnership, particularly in the tax area. So the LLC is formed when you have articles of organization, which we'll see at the bottom there. Documents that are required are filed with the Secretary of State, which then brings that LLC into existence as a person. In terms of ownership, the LLC is owned by one or more persons, which we call members. So in the LLC, we have members. Corporation, we have shareholders. Partnership, we have partners. And then in the sole proprietorship, you have the sole proprietor. Okay, so the owners are members in the LLC. In terms of liability, since the LLC is a person, it's liable for its own debts and claims, and the owners or members are not liable for those debts and claims of the LLC. But also, there's specific statutes which limit the liability or that indicate that the members are not liable for the LLC debts. Then we have, in terms of taxation, this is where the LLC is the most flexible, where it can be treated for tax purposes as a sole proprietorship, partnership, or corporation, depending upon the circumstances of that particular LLC. So the LLC would not be taxed as an LLC. It's going to have to be classified for tax purposes as a sole proprietorship, partnership, or corporation. And depending upon the facts and circumstances, of that particular LLC, it will fall into one of those categories. By default, if there's no particular elections or anything made, by default, if it's a single member LLC having one owner, one member, it would be a sole proprietorship for tax purposes. If it has two or more members, by default, it would be a partnership for tax purposes. Then it can choose if it wants to be treated as a corporation for tax purposes. There's additional documents that get filed, and then the IRS can recognize it as a corporation for tax purposes. It's an LLC under state law, but it would be a corporation or one of these other structures, what other classifications for tax purposes. In terms of documentation, uh, um, there's a lot of flexibility, but there's the operating agreement, and then there's minutes and resolutions that are created and maintained internally. Now, it's possible to have an LLC without a written operating agreement. Not advised, but it's possible. Um, it is something that that in terms of doing these classes, these workshops of this nature, one of those things to stress so that individuals who are going out to set up companies, set up LLCs, that they consider speaking with legal counsel and understanding the range of options available to them before simply filing the documents with the Secretary of State. There are a wide range of things available to you, especially with respect to some of the changes, and we'll go into those in just a few moments. But a lot of times folks will just go in their file and they'll create this entity, and they have not looked at what the options that were available to them are. So when we talk about the limitation of liability, how that structure is protecting the assets of the business from or of the business owner, their personal assets from claims against the business, it also works the other way as well. In this image here, you see the LLC barrier in the middle. So if there was a claim from the personal side, so let's say the member of the LLC was in a car accident, and he was the at fault party, and the claim exceeded his insurance, or maybe he didn't have insurance. Question would be, can that claim against him, can it be used to take assets out of the LLC? And under the law, and depending upon what's in their operating agreement, there would be some protection between the claim out of his personal affairs and the assets of the LLC. Okay, so then the LLC would not be exposed to liability arising out of that owner's or that member's personal life. Okay, and then vice versa, as we described earlier. So that's just a simple depiction of that. So in showing what a complete LLC is, it's more than just going and filing the articles of organization with the Secretary of State. The complete LLC is one that is properly formed and has created and maintains all of the required documentation to evidence its existence, its ownership, management, and authority, and its decisions. And this definition here, we used to say having documentation to evidence its existence, its ownership, and decisions. But with some of the changes in the new law, that second category, we have expanded it to be ownership, management, and authority. Those are some specific aspects of the LLC that are important to document, and that impact how individuals and other parties engage with that LLC. In terms of showing who owns it, or who has the authority to sign on behalf of this LLC, who is going to run the day-to-day affairs of this LLC? Is it the members? Is it the managers? Or are we going to structure where our LLC actually has roles within it that are very similar to officers and a board of directors like in a corporation. Because there's a lot of flexibility that's allowed for LLCs today under the new law. So in terms of a sort of a graphical depiction of the LLC that is properly formed, evidence of existence. Let me pull out the laser pointing here. Evidence of existence, evidence of ownership, management, and authority, and then evidence of decisions. You'll see that when we talk about that the LLC is properly formed, that we're going to talk about the articles of organization, which get filed, and then also the operating agreement. For certain aspects, certain things that you, okay, all right, sorry about that. So there's documentation that's required. You have your articles of organization that get filed, but then the operating agreement is required in terms of whether it's properly formed, because sometimes there's language that needs to be in the operating agreement and certain language included in the articles of organization in order for this to be a proper entity. So there are some decisions then that need to be made before you go down to file with the Secretary of State, because it's possible in Ohio to have an LLC that is a nonprofit LLC. So it does not have to always be a for-profit entity. And so let's say if you want to do a nonprofit LLC, then you're going to want to put certain language in there for the purpose of that entity, which shows that and establishes that it is a nonprofit. It has nonprofit purposes, and then detail what those purposes are. So these are decisions then that would be made before someone goes to the Secretary of State to file their documents. And then the same would be with the operating agreement, certain provisions that would need to be included in that operating agreement. So whereas it's possible to have an LLC without an operating agreement, there are certain things that will require that it actually be in writing. Okay, but that's going to come from either the individual knowing that they have those options, or speaking with professionals to help advise them how to accomplish what they're looking to do. So in terms of the evidence of the existence, after the articles of organization are filed with the Secretary of State, then the Secretary of State will issue a certificate. In Ohio, they'll issue a certificate to that owner or to that company, showing that that it does exist, that the Secretary of State has possession of those articles. And then you can also have an operating agreement, which helps to document and evidence the existence of that entity. Then when we come around to evidence of ownership, management, and authority, so this is one of the new provisions under the new law, what's called a statement of authority, which is a document that gets filed with the Secretary of State, which indicates who a specific individual or a specific position within the LLC that is authorized to sign documents and enter transactions on behalf of that LLC. Okay, so that's something that's new in the state of Ohio under the new law, where you can put on record who or what position within the company has the authority to actually enter into this contract on our behalf. And then also you're going to have provisions within the operating agreement that also address the ownership and who's responsible for management, and then identifying who can be put onto the statement of authority. And then finally, in terms of evidencing the decisions, we say that the LLC, much like the corporation, that when it's formed, like when you file the articles, it's recognized as a person, but it does not have a physical body. So then how is it going to speak? It's going to speak through those minutes and resolutions, those written documentation of the decisions that are being made by those responsible parties, be it the members, be it the managers, be it the officers within that company structure. Okay, so that's sort of a graphical depiction of the complete LLC. And then one thing that I sort of came up with as after looking at the law, looking at the different things that are now available to business owners or LLC owners in Ohio, and it's sort of like the Swiss Army knife of business entities. And at the core of that, you'll see sort of the body of the knife, the red part um, here is the operating agreement, because everything can be built around and built off of that operating agreement. And the one principle, the governing principle, freedom of contract, which means that um, individuals, Ohio is looking to recognize the agreement, the decisions, the agreements between the parties. So your operating agreement, there are a few provisions that are prohibited. There's a certain list of things that you cannot do. You cannot put into your operating agreement. But outside of that, the parties are free to arrange their relationship between one another, between themselves and others, or in terms of the assets that are being brought in, or who's obligated for what. It's freedom of contract. Parties can negotiate and structure that with the maximum amount of freedom. It's aside from the specific things that are prohibited by law. They have all that freedom, and you can see then that off of this structure down to the left, it can be a for-profit or nonprofit. So those are different tools that are available. Then you also have this new aspect in Ohio, and it's part of a growing trend across the country, with what's called the Series LLC, which sort of sets it up as it's an LLC. You have your master LLC, and then you're going to have what's called series, which are almost like many LLCs that are underneath the master LLC, but they're called a series. So they're not a separate entity. They are a series of this one LLC. So you set it all up within the one structure, and it gives a lot of flexibility to the entity and to the owners of that, and it creates a lot of opportunity for some flexible and creative approaches. Then you're going to have, as part of this Swiss Army knife of business entities, the flexible tax treatment. We talked about how it can fall within the sole proprietorship, partnership, corporation. It could also fall within the nonprofit range as well. Okay, so there's a lot of flexibility in terms of tax treatment of the LLC. And then we have the idea of privacy and anonymity. There are many times, or there's sometimes, folks want to set up a company, set up a business, and but they want to have some privacy. They want to own it, but they don't necessarily want the public to be able to run to the Secretary of State and plug in their name and find what companies they own, what properties that they own. So the LLC can be structured to provide some level of privacy and anonymity. And this is another aspect that, if someone is looking to maximize privacy and anonymity, they're going to want to talk with legal counsel early, so that they can know what options are available and what approach to take to minimize the exposure of their name on the public record. Would there be someone else who does certain roles that are on the public record, and then the owner is behind the scenes? So that's one aspect when we talk about some of the challenges or some of the things that happen when folks run down or go online and file their articles, by themselves. They sort of give up some of these other aspects that they may not even have known about. And then finally, under the new law, there's going to be some creative ownership and management structures. That goes back to the freedom of contract, in terms of being able to determine, who are the owners, who are the members, what happens with the membership interests, and we'll talk about a little bit of that as we get into some of the code sections here. But there's a lot of flexibility to be creative with the structuring of one's LLC. under Ohio's new law. So moving forward here, so the new law became effective back in April of 2021, and it's called the Ohio Revised Limited Liability Company Act, or the LLC Act. And then it became applicable. So it became effective in 2021. Then it became applicable to all LLCs in the state, those that were in existence, those that were being formed after that date, on February 11th, 2022. Okay, so almost a year later, a little less than a year later, it became applicable to all LLCs in the state. Okay. Then, so the new law, details what constitutes an LLC, or what is an LLC. A limited liability company means any entity formed or existing under this chapter, and they have it under what's called Chapter 1706 of the Ohio Revised Code. Which they made so many revisions. It used to be 1702. They created an entirely new chapter to do the LLC under. So they just rewrote they wrote a whole new chapter, and then did away with the old chapter. So the organizational documents, and this may vary with some of the terms from state to state. But in Ohio now, when we say organizational documents, it means for the limited liability company, the articles of organization, which we talked about, and the operating agreement, or if it's a foreign LLC, it would be comparable records to those under the statutes of that state. And when we say foreign LLC, we're talking about an LLC that was formed under the laws of another state, but it's doing business in Ohio, which means it would then have to register as what we call a foreign entity. So it did not originate in Ohio, but it's going to operate here, and as a result of that, it has to register here. So they may have started the business in Texas, so it would be a Texas LLC. But if they're going to have an Ohio office and operate here, then that Texas LLC would have to register as a foreign LLC here in Ohio. And so then organizational documents, because I've done some work in the past with Texas, and they use a certificate of organization instead of articles of organization that we use. They call their certificate of organization. All right. So then also, as we've mentioned, in terms of the operating agreement, it's written. It can be written or oral, as indicated here, between the members, or even if you have a single member LLC, just one individual, then we call it a written declaration. And there are times when you want to have that as well, where that individual, that sole member, does the written declaration, so they can lay out all those same type provisions for how they want this LLC to operate. And they may even have it where they are the sole member, but they may actually want to have a manager within the LLC structure that operates their company. So this sole member is the owner, but the manager will be in place to do some of the day-to-day affairs type thing for that LLC. So you can structure it that way. You don't have to make everyone an owner of your LLC. You can be a single person, single owner, single member, and have others who are actually running the day-to-day of that company. And we talked about written declaration, which is for a single individual. Their agreement. And then statutory agent. This was a big change in the new law. So the statutory agent, we mentioned how the LLC and the corporation don't have a physical body, but they are a person. So it's required that they have a person who maintains an address, a location in the state that can be served with formal process, meaning that if there's a complaint or some notification, some legal or formal notification, there's a statutory agent that it can be served upon. So it doesn't, and the statutory agent doesn't have to be in Ohio, it doesn't have to be the corporate headquarters of that business, that LLC or corporation. It's just that person who can receive that, and once they receive it, it's deemed that that LLC has received that document. They've received that notice. So the change has been is that it can be canceled for failure to maintain statutory agent updated address. Many times over the years, folks will go down, set up their corporation, set up their LLC. LLC is the predominant one, and they may name themselves as the statutory agent. But let's say they were living in an apartment when they set up their LLC. They went ahead, they've moved to two different places, and they have a house now, in Columbus, in Cincinnati, wherever they may be. But they've changed addresses, but they did not go back and update the statutory agent address with the Secretary of State. And so now, if notices get sent, it's not going to reach the company because the statutory agent has moved on, and there's a disconnect. So now, if that happens, the Secretary of State can send notification to the last known address. If it's not responded to, the information is not updated within 30 days, then the Secretary of State will cancel that LLC's registration. So now, by failing to maintain an up-to-date statutory agent, could result in a cancellation of that LLC structure. Okay, so that's a very big change, and I would imagine within a year or so we'll probably start to see this issue start to come up as more and more of these bad addresses start to surface. Then, in terms of the management structure, the new act, it used to be that you would call an LLC either member managed or manager managed, meaning that the members of the LLC run the day-to-day affairs, or they appoint managers, which could be members or non-members, who oversee the day-to-day affairs. So the new law eliminates that and allows the LLC, through their operating agreement, to define how they're going to be, what their purpose is, and how they're going to be managed, which will end up as member managed or manager managed, but you don't have to make that as a designation up front. And then in terms of we talked about the statement of authority. So in terms of the management structure and who's allowed to act on behalf of the LLC, there are provisions that provide for that in the new law as well, which then culminate with that statutory statement of authority, where you notify the public, you put it on the public record of who's able to do that. And that helps protect the public, so that when someone comes in and says, "Oh, I'm signing this lease agreement on behalf of ABC, LLC," then that party can go online, go to the Secretary of State, pull down the statement of authority, and say, "Oh, okay, so that is a recognized individual or a recognized position that's permitted to sign this document." So it helps to bring a little bit more certainty to those transactions. Then we talk about a member. So a member is a person who has been admitted as a member to the LLC pursuant to the statute, which is important because the member is that person, and their ownership interest, them being part of that LLC, their membership interest is the right to receive distributions from that LLC or a series of that LLC. So the distributions would be the payment of funds or money from that LLC. So you have the member and the membership interest. The membership interest is that right to receive those distributions. So there is a separation there between those. So it's possible when you look at the statute here, they say a person may be admitted as a member without acquiring a membership interest and without making or being obligated to make contribution to the LLC. So it's possible to have a member of the LLC who has they're not receiving any financial distributions. The right to receive the distributions may be given to someone else or another entity, or maybe that membership interest was created to not have that at all. So it brings up a lot of flexibility, a lot of differences, different structures that can be done within this LLC. But that one prime example of that could be, if it was a nonprofit LLC. So with a nonprofit LLC, you're not looking for members to receive financial distributions anyway, because there are no quote unquote owners of a nonprofit organization. So they would not need a financial interest, or the right to receive distributions. So that would be a context where you would separate those two. But it does provide a lot of flexibility in terms of structuring one's LLC when you look at it that way. And then as we get closer to the end here, you have the series LLC, which, as we described, is the having the master LLC, and then you have the series, which separate and isolate liabilities, separate assets within that structure. Where, let's say, if you had houses, that the LLC was owning. Here's an example here. So this is one LLC. So we have master LLC up here, and then you have a series. So a series can own property, or it can be separate lines of business. But let's say if something happened in series, we have series company 2. It says pet store. So if there was an incident, some bad pet food, and so folks started suing because their pets were eating the food and not doing well. So it may be that series gets overloaded, overrun with claims. And let's say if it had $10,000 in assets and the claims were for 200,000. So that would exceed all the assets of that series. So a question would be, would series 1 or series 3 have to pay the remainder of that claim, or would the master LLC have to pay the remainder of that claim? Under the new law, Ohio law, that liability stays right there with series 2. So the other series 1, series 3, and also the master LLC are not liable for anything that comes out of this series 2. So that claim for that 200,000 is only in that one point, that one series. So that's how that would work there with the series LLC. So that's another option that's available under state law, and that's where another provision where there's a requirement for language in the operating agreement, language in the articles of organization. So there's some specific things that have to be done in order to create that entity. Then we have we talked about anonymity. And I think there was a question in the beginning about anonymity as well. And so it's possible to structure the LLC to maximize, that anonymity in terms of, not disclosing the identity or names or home addresses of certain owners or members of that LLC or managers of that LLC. So, but those would be things that one would work through with their legal counsel. And there's references to some of the statutes at the bottom that pertain to some of that privacy aspect, some of that anonymity aspect. So it's possible to minimize that, but you do want to talk about that up front with an advisor. All right, we've already talked about that, and we can open it up for questions and answer. Um, I know that we are
I have a
just about
question.
out of time.
I know we're close on time. I have a question, Ambrose.
Yes.
So, with the state of Ohio in particular, you used to have to file your articles of organization with the actual as part of your paperwork to get your business certified as a recognized as a business. Then it went to they streamlined the process and you just had to do their form. And that's basically what is the nature of your business, your address, your name, if there's any members, what structure and who the statutory agent is that you just talked about.
Mhm.
So with these new changes, is it required now that you have to submit your articles of organization in order to become a recognized business in the state of Ohio?
So when you say recognize, you mean certified, like MBE?
Certified, yes. Yes.
Um, I, I, I don't, I don't know about that part, the certification part. I could imagine that it could be similar to the process that you described, because whatever you put on the form, if you say that we're an LLC, da da da, they can go to the Secretary of State's and check, and if they don't find it, then they're saying it doesn't, you know.
No, 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 no. What I'm saying is when you file with the Secretary of State,
Hmm.
the article of organization, you should always do that. So I always tell people to do that.
Hmm.
But they have streamlined their process to the point that you didn't have to turn that in with their state form.
Oh, are
So
you talking about when you
so I'm
file
asking, do
online?
you have to
Uh,
do that? Now with
oh,
with certifications like small business, minority business, yes, you have to supply that and a copy of your operations agreement. That you do.
so,
But I'm talking about actually I have a
uh,
company, I want it to be a LLC, I need to register with the state of Ohio.
yes, well, it's all online. You can do it online. So you provide the
Hmm.
information, and then they generate the system generates the final actual document, the actual
Right.
articles. Yes. So it's generated in the system. You don't have to type it up and then upload it. They generate it.
Well, that's something new. That's why I'm asking
Mhm.
what is in there. Okay.
Yes, yes. And so as part of that process online, when you get towards the end of it, there is an option to preview the document. And when you do the preview, it'll show you, it'll pull up, and then it's going to show it on the form. You'll see like a
Hmm.
PDF that'll be filled in with whatever information you provided. So they do provide that option at the end of that online process.
Yeah. And the state of Ohio is really good with processing. Like I said, they've streamlined the process. I remember back in the day when I was taking paperwork for other people up to Columbus just to cut off 2 weeks of processing because it used to take them
Uh-huh.
like 6 weeks. Now it's like 3 to 5 days, even though they give themselves a 2 week window. So
Right.
it's a lot faster. But like you said, you really need to have your articles of organization, your operations agreement, and things like that in place.
Hmm.
I experienced a dissolution of a business from a partnership, and I'm glad I had that in place because some of the things that they were doing, I
Hmm.
would have been caught up in all kind of tax mess and other stuff.
Yes.
So those are critical because when money starts flowing in, people, they forget what they agreed upon. So, and then as a single person, is good to have because it's keeping you consistent in
Right.
in how you operate your business or if you want to get investors later down the line and things like that. So,
Exactly, exactly. Yeah, those are some prime examples for even as a single member to have that
mhm.
documentation, to have that written declaration, but also if you're going to be a single member LLC, but you're wanted it as a series LLC, then you would have to you would be required to have that written declaration and to have those provisions in there. So.
Yes.
So but that's again, that's just where the whole idea, I think one of the points here is that going into these business structures, or even as a nonprofit, so as an organization looking to do a nonprofit, or if they're looking to do a co-op, those are the kinds of provisions that would go into the operating agreement. So, so it's just important, when we talk about the legal nature of the legal environment of business or legal environment of the community, that those aspects be taken into consideration. So that they have to
Right.
go beyond just the initial filing of those documents.
Correct.
So, are there any other questions? I'm sorry for going a little bit over, but I still want to answer any questions that folks have. I know we had some in the beginning before we got started, but
So, Jody, did your question get answered?
Well, I don't know that I understand still, although I learned a lot of things, so I'm just trying to take it all in. But it just sometimes in the past, I don't suppose I can think of a good example, but is it better off when you're doing an LLC is in some situations is less more? I mean, or is it better to have all the detail and everything in there? Is it better to
well,
be
I think
less
that
more and be broad or
yeah, I think that that's going to really that's another good reason to work with counsel, because it may be that your structure would be very simple, where like we said, well, even a single member should have a written declaration, but it could be a very simple written declaration because you don't have any intention to bring in any other members or owners or investors. So the amount of detail can vary from person to person, in terms of how they're operating. So,
And also, if you start your business off one way and it grows and you decide you want to change it up a little bit, you can always do an amendment, but you have to make sure that you file those amendments with the state so it can be recognized.
then
well, oh,
oh,
I'm sorry.
then another thing is the past situation, but somebody had purchased some land adjoining to us, but the LLC was written so vague you couldn't even tell what it was about. Maybe that's just normal business.
I mean, they could have done it bad. I mean, they could have done it improperly or poorly. And that's one thing that I have seen. And another reason why this aspect of sort of educating folks is that we need to make sure that we have properly structured business entities, because what's happening, when outside of my work with Central State, when I've been involved with different court matters where folks who have improperly set up their LLC or corporation, now they're in court with this improperly structured document, but then they have an attorney who's actually advocating things, sort of promoting this improper structure. And so that sort of infuriates me, because you run the risk of having bad law created, because you got someone, instead of correcting the structure, they're arguing to support this poorly structured business. So it can end up with some sort of unintended consequences. I just think that starting from the beginning, if we have proper structures, it can help reduce some of that. You're not going to completely eliminate it, but you want to try to reduce it. All right.
Thank
If there are no other questions, I want to thank you all for spending some time with us. Next week, we will be talking about nonprofit organizations, social enterprises, and benefit corporations, as we continue getting into our legal environment of business and community.
And can you describe really quick what benefits corporations, what a B Corp is, just so people will know, because that's a new term.
Well, that's for next week.
But it's still it's
Oh,
just
okay. So benefit corporation, um, when we talk about for-profit and nonprofit, and those, that really relates to the purpose of those entities. So when we talk about a benefit corporation, it is a for-profit corporation, but it's operating more for a social purpose. What's called a social purpose.
that's it.
And
That's all you
and
need.
and, and okay, and we'll
That's
get
your
into more
teaser.
detail next week. So
Yeah, that's your
uh,
teaser.
but it's a very, very folks have been trying to get it in Ohio for quite some time, and now we finally have it. So it's a good opportunity, I think, for folks to start using that. So, but next week, and we'll talk about nonprofit, social enterprise, and benefit corps. All right, that's all we have, folks. Thank you.
Thank you, Ambrose. Thank you, everybody.
Thank you.
Thank you.
Bye-bye.